Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing self-defense laws in Canada, and in particular, self-defense when a homeowner is faced with a home invader. How far can you go to protect your home from an intruder? Two recent cases, one in Ontario and one in Nova Scotia, have proceeded on starkly different paths. Now, while we don't know the facts of all the cases, it's early stages, both did involve homeowners responding with lethal force to multiple thieves. In Halifax, two men tried to break into a home when they were accosted by one of the residents, and one of the intruders was stabbed to death, but no charges were laid. But in Milton, Ontario, a resident was charged with second-degree murder after as many as 4 men, at least one with a gun, tried to break into his home. What leads to the decision by prosecutors to charge or not charge in these types of home invasion cases? Here to discuss this are two experts, Professor Lisa Dufraimont of Osgoode Hall Law School and criminal lawyer Karen Bastow. Thank you both so much for joining me today. Lisa, let's start with, at a high level, what does self-defense law look like in Canada? Can you give sort of a high-level summary of how the law works?
Thanks, Christine. I'd be happy to do that. So there's a section of the Criminal Code, Section 34, that covers a defense that I think is properly called defense of person. And I call it defense of person because it applies not only when you're defending yourself, but also if you're defending someone else. And what this section does is it says that something that would otherwise be an offense might not be an offense or is not an offense if the person has done that act and it's a reasonable act, and they've done it for the purpose of defending themselves against a force or threat. So an obvious example would be if I have stabbed a person and I've done so intentionally, normally that would be an offense, an assault offense, or perhaps a homicide offense if I kill the person. But if I've done it because that person was attacking me with a baseball bat and I was defending myself, and that's why I stabbed them, then I could have the defense of defense of person under Section 34 of the Criminal Code.
Now, I want to get into the proportionality conversation about how force needs to be proportional, but I want to save that for a little later in the segment. First, I want to give Karen an opportunity to add anything you want about how, at a high level, self-defense works in Canada.
Okay, well, I'm going to actually just briefly add that the self-defense law, as it's developed in the court decisions and also in the amendments of 2013, is that there is a consideration of the individual and subjective perception of the person that's being attacked. And what that plays out as, in a practical sense, is traditionally you can't expect someone to respond with sort of the niceties of force when faced with a sudden and shocking act. And this is especially true in cases with juries. Juries are sympathetic to self-defense cases. And so although the law looks very cut and dried, when you actually get to court, the personal characteristics of your client, the accused, are very important. So there's, for instance, the case of an Army reservist. And he said, well, I'm an Army reservist. And I have particular responses to violence that are different from the average citizen.
Now, I want to talk about these two cases I mentioned in the opening, Lisa, and we have to acknowledge we don't know all the facts here. But what is the difference that led to, in the Nova Scotia case, the homeowner not being prosecuted, and in Milton, it seems at a high level of similar facts, not being charged or being charged? I'm sorry, charged in Milton, not charged in Nova Scotia.
Right. So the answer to your question of what is the reason that the result is different, I really have no idea. That comes down to the prosecutorial decision making and the decisions made by the different prosecutors dealing with those cases. What I would say is that Section 34 has 3 requirements. And it must have been that in the one case, those requirements were thought to have been met. And in the other case, for whatever reason, those requirements were thought not to have been met. The first requirement of the legislation is that the person who has acted has to have had a belief a reasonable belief or a belief on reasonable grounds that force was being used against them. And that seems to be something that would be applicable in both cases. There were invaders in the home and perhaps there was some threat or force being used.
Right.
Then they have to have committed the act that would be the offense for the purpose.
We've actually got to go to break, but let's follow up on this after.